Welcome to our deep dive into Chapter II of the Bharatiya, Nyaya Sanhita, BNS, which explores the general exceptions and defenses available to those accused under BNS or any special or local law. This chapter is crucial because it shapes how offenses and penal provisions are interpreted, ensuring fairness and justice in criminal proceedings. We'll journey through the core principles, burden of proof, and the two main classes of exceptions, excusable and justifiable. At the end, you'll understand how these exceptions operate and why they're fundamental to criminal law. Criminal law, the prosecution must prove the accused's guilt beyond reasonable doubt. If evidence creates uncertainty, the accused is entitled to acquittal. However, when an accused claims a general exception under BNS, the burden shifts. They must prove circumstances that justify their defense. This balance ensures that the prosecution cannot simply rely on the accused's claim, but must be met with credible evidence. Understanding this burden is key to appreciating how exceptions work in practice and why they are not automatic shields for the accused. Chapter III distinguishes between excusable and justifiable defenses. Excusable defenses arise when the act lacks criminal intent, mens rea, meaning the accused did not intend to commit a crime. Sections 14 to 33 of BNS cover these. Justifiable defenses, on the other hand, involve acts that are justified due to circumstances neutralizing liability, even if the accused had intent. Sections 34 to 44 address these. This division is foundational, helping courts decide whether an act should be excused or justified based on the facts and intent involved. Section 14 of BNS deals with acts done by a person bound or mistakenly believing themselves bound by law. The maxim ignorantia facti excusat, ignorantia juris non excusat, means ignorance of fact is an excuse, but ignorance of law is not. Mistake must relate to fact, not law. For example, if someone believes a person is a ghost and acts in good faith, they may be excused. However, ignorance is not accepted when reasonable inquiry could reveal the truth, or when strict liability applies, such as selling adulterated food. Several cases illustrate the boundaries of mistake as a defense. In R versus Prince, 1875, the accused's mistaken belief about a girl's age was not a valid defense since he intended a wrongful act. In Shearers versus de Rutsen, 1895, supplying liquor to a constable based on mistaken belief about duty status was still an offense. Rex versus Levitt, 1688, showed that acting in ignorance without intent to harm could excuse liability. These cases clarify when mistake of fact is accepted and when it is not. Obedience to illegal orders from a superior is not excused under Section 14. If a soldier fires on a mob following an illegal command, he is liable for the offense. The excuse of superior order may only mitigate punishment, not absolve liability. This principle ensures accountability and prevents blind obedience from becoming a shield for unlawful acts. Even foreigners or those unaware of new statutes cannot plead ignorance of law as a defense. Sections 15 and 16 of BNS provide exceptions for acts done by judges acting judicially and acts done pursuant to court orders. These sections recognize the importance of judicial independence and protect judges and those acting under court authority from criminal liability, provided their actions are within the scope of their duties. This ensures the smooth functioning of the justice system and prevents undue interference with judicial processes. Section 17 deals with acts done by a person justified or by mistake of fact believing themselves justified by law. The mistake must relate to fact, be committed in good faith, and the person must believe they are justified by law. The distinction between Sections 14 and 17 is that Section 14 involves legal compulsion, while Section 17 involves legal justification. Important cases like Keshav Sahu versus Shalagram Shah, 1977, and Charan Das, 1950, illustrate these principles. Section 18 covers accidents occurring during lawful acts done without criminal intention or knowledge, using proper care and caution. Criminal law requires both intent and act to concur for liability. Illustrations include accidental deaths during school discipline, necessary force in self-defense, and accidental deaths during lawful activities. However, if the act is not lawful or lacks proper care, the defense is not available, as seen in Jadeshwar versus Emperor, 1924. Burden of proof for accident as a defense lies with the accused, who must show their case falls within the exception. Contributory negligence is not a defense in criminal law, as established in R versus Swindoll and Osborne, 1846. This ensures that criminal responsibility is not diluted by the victim's negligence and maintains the integrity of criminal proceedings. Section 19 allows acts likely to cause harm, done without criminal intent, and to prevent other harm as a defense. The act must be in good faith and aimed at preventing greater harm. The doctrine permits inflicting lesser evil to avoid greater evil, as illustrated by the case of two drowning men struggling for a plank. Only certain situations qualify as necessity, emphasizing the importance of intent and circumstances. Doctrine of self-preservation raises questions about harming others to save oneself. In R versus Dudley and Stevens, 1884, adults killed a child for survival, but the court denied the defense of necessity, holding them liable for murder. Dr. H.S. Gower's principles clarify that self-preservation is not absolute, and no private necessity justifies homicide except in self-defense or public justice. Us's case illustrates necessity in property situations. A shipman threw goods overboard to reduce the ship's weight and was not guilty. This shows that necessity can justify acts to prevent greater harm, provided the act is not excessive and is done in good faith. The principle balances individual rights with public safety and welfare. Section 20 provides immunity for children under 7 years of age, considering them doli incapax, incapable of criminal intent. Both English and Roman law recognize age thresholds for liability. In India, children below 7 cannot be held guilty for offenses, reflecting the principle that young children lack the maturity to understand the consequences of their actions. Section 21 grants qualified immunity to children above 7 but below 12 years. They are presumed doli capax, capable of criminal intent, unless proven otherwise. If a child attains sufficient maturity, they are liable. If not, they are exempt. Cases like Ulla Mahapatra, 1950, and Krishna, 1883, demonstrate how courts assess maturity and intent in young offenders. Ulla Mahapatra, 1950, involved an 11-year-old who killed with intent and was sent to reformative school, showing full maturity. Krishna, 1883, saw a 9-year-old held liable for theft, while Mariamutha, a 10-year-old, was not liable for picking up a button. These cases highlight the nuanced approach courts take in determining criminal liability for children. Section 22 addresses acts by persons of unsound mind. English law offers several tests for insanity, including the wild beast test, insane delusion test, and the capacity to distinguish right from wrong. The McNaughton case, 1843, established that insanity must exist at the time of the crime, and the accused must be incapable of understanding the nature or wrongfulness of their act. To establish insanity, it must be shown that the accused was of unsound mind, incapable of knowing the nature of the act, its wrongfulness, or that it was contrary to law. This incapacity must exist at the time of the crime. Legal insanity differs from medical insanity. Only legal insanity provides a valid defense in court. Cases like Fulabai versus State of Maharashtra, 1976, and Chukappa Tamana Lingadi demonstrate how courts apply these principles. Madness can take several forms: idiocy, periodic lunacy, illness-induced unsoundness, or drunkenness. Simple drunkenness is not a defense, but prolonged intoxication leading to delirium tremens may qualify. Irresistible impulse is not a defense under Section 22, though it may reduce punishment. This nuanced approach ensures only genuine incapacity is excused. Section 23 covers acts done by a drunken person where intoxication is involuntary, against their will or knowledge. If the accused did not know the nature of their act due to involuntary intoxication, they may be excused. The leading case, Director of Public Prosecution versus Beard, 1920, illustrates how courts distinguish between involuntary and voluntary intoxication. Section 24 deals with voluntary drunkenness, which is generally not a defense. The law presumes the intoxicated person has the same knowledge as if sober. Cases like Mead, 1909, Beard, 1920, and Gallagher, 1963, show that voluntary intoxication does not excuse criminal acts, especially when intent was formed before drinking. R versus Mead, the accused killed his wife while drunk and was convicted for murder. In Gallagher, 1963, intent to kill was formed before drinking, so drunkenness was not a defense. Lipman, 1970, involved drug-induced hallucinations leading to manslaughter. Indian law, as seen in Basudev versus State of Pepsu, 1956, treats voluntary intoxication as no excuse for criminal acts. Section 28 outlines when consent is not free. Consent must be given by a capable person, freely and intentionally. Consent under fear, misconception, by a child under 12, by an unsound mind, or by an intoxicated person is not valid. The maxim Volenti non fit injuria means a consenting person suffers no harm. Consent is central to many defenses, but only valid consent counts. Sections 25 to 29 relate to consent. Section 25 states that consent is a defense for acts not intended or known to cause death or grievous hurt, provided the person is above 18. Consent is a good defense for offenses against property and body, except those causing death or grievous hurt. However, consent may reduce murder to culpable homicide, but never justifies death or grievous hurt. Section 25 requires the person giving consent to be above 18, and the act must not involve death or grievous hurt. Consent can be express or implied. If consent is given for a dangerous act resulting in death, the accused may face mitigated punishment. The principle is that consent never justifies death or grievous hurt, maintaining the sanctity of life and bodily integrity. Section 26 covers acts done in good faith for a person's benefit, with consent, and without intention to cause death. The act must be for the benefit of the person, and consent can be given by anyone above 12. Even if harm is intended but not death, the defense is available if the act is done in good faith. Cases like Sukuru Kaviraj, 1887, show that lack of due care can negate the defense. Section 27 allows acts done in good faith for the benefit of a child under 12 or an insane person, by or with the consent of a guardian. Consent may be express or implied. The defense is not available for acts causing death or grievous hurt or for pecuniary benefit. Illustrations clarify when the defense applies and when it does not. Illustrations under Section 27 include acts done for a child's benefit, such as medical operations, but not for pecuniary gain or causing death. For example, a guardian consenting to surgery to prevent death is protected, but not if the act is for financial benefit or causes grievous harm. The distinction ensures only genuine acts for welfare are excused. Section 29 excludes acts that are offenses independently of harm caused. Consent only condones harm to the consenting person, not acts that are offenses regardless of harm, such as causing miscarriage or immoral acts. This ensures that public justice and morality are upheld, and consent cannot be used to justify inherently criminal acts. Section 30 covers acts done in good faith for a person's benefit without consent, when circumstances prevent obtaining consent. This protects medical practitioners who operate to save lives when consent cannot be obtained, such as in emergencies. The law recognizes implied consent in such situations, balancing individual rights with urgent necessity. Section 30 recognizes exceptions to implied consent, similar to Section 27, but extends to voluntary causing of hurt or attempts to cause hurt. The difference is that Section 27 requires guardian consent, while Section 30 operates without any consent, relying on circumstances. This ensures urgent actions for benefit are protected, even when consent cannot be obtained. Section 31 provides that no communication made in good faith for a person's benefit is an offense, even if it causes harm. For example, a surgeon telling a patient about their prognosis, even if it causes shock and death, is protected. This section recognizes the importance of honest communication in medical and legal contexts, ensuring professionals are not penalized for necessary disclosures. Section 32 states that, except for murder and offenses against the state punishable with death, acts done under compulsion by threat of instant death are not offenses. The person must not have placed themselves in the situation voluntarily. Explanations clarify when compulsion is a valid defense, such as being forced by dacoits, but not when joining a gang voluntarily. Section 32 is based on the maxim, Actus me invito factus non est mens actus, an act done against my will is not my act. Threat of being beaten is not a defense, only threat of instant death qualifies. Compulsion from necessity, such as starvation, does not excuse criminal acts like theft. The law carefully distinguishes between genuine compulsion and voluntary actions. Section 33 provides that acts causing slight harm, which no person of ordinary sense and temper would complain about, are not offenses. The maxim, de minimis non curat lex, means the law does not concern itself with trifles. This exception applies to both accidental and deliberate acts, provided the harm is trivial and not worthy of legal action. Examples of slight harm include taking pods of little value from government land, theft of a worthless check, or minor reputational harm. These acts are considered too trivial for legal action. However, acts like assaulting a police superintendent, tearing up a debt paper, or disrespecting a witness are not trivial and are liable for prosecution. The law distinguishes between minor annoyances and genuine offenses. Rupan Diol Bajaj vs. KPS Gill, 1995, Gill assaulted a woman at a party and claimed the act was slight. The court rejected this defense, stating that the trauma and indignity suffered were not trivial. This case underscores that the law does not excuse acts causing significant harm or outrage, even if the accused claims the harm was minor. Chapter III of BNS provides a comprehensive framework for general exceptions, balancing individual rights with public safety and justice. From mistake of fact, accident, necessity, and insanity to consent, compulsion, and slight harm, each exception is carefully defined and limited. Understanding these exceptions is essential for anyone studying or practicing criminal law. Any legal principles and maxims underpin the exceptions in Chapter III. Ignorantia facti excusat, Volenti non fit injuria, de minimis non curat lex, and Actus me invito factus non est mens actus guide the interpretation and application of defenses. These maxims ensure clarity, consistency, and fairness in criminal law. Good faith is a recurring requirement in many exceptions, such as accident, necessity, consent, and communication. Acts done in good faith for another's benefit are often excused, provided they meet legal criteria. This principle ensures that only genuine, well-intentioned acts are protected, preventing abuse of defenses. Age and mental capacity are crucial in determining liability and the applicability of exceptions. Children below 7 are immune, those between 7 and 12 have qualified immunity, and persons of unsound mind may be excused if incapable of understanding their acts. These provisions ensure fairness and recognize the limitations of certain individuals. Intent and knowledge are central to criminal liability. Many exceptions hinge on the absence of criminal intent or knowledge, such as accident, mistake of fact, and involuntary intoxication. The law carefully distinguishes between acts done knowingly and those done without intent, ensuring only culpable acts are punished. Exceptions cannot be used to justify acts against public justice or morality, such as causing miscarriage or immoral acts. The law prioritizes societal values and ensures that individual consent or necessity does not override public interests. This maintains the integrity of the legal system and protects vulnerable groups. Practical implications of Chapter III are vast. Legal practitioners must carefully assess facts, intent, capacity, and circumstances before invoking exceptions. Courts scrutinize claims of accident, necessity, insanity, or consent to ensure they meet legal standards. This rigorous approach upholds justice and prevents misuse of defenses. Conclusion: Chapter III of BNS provides a robust structure for general exceptions, balancing individual rights, public safety, and justice. Understanding these defenses is essential for legal professionals and anyone interested in criminal law. The chapter's principles, cases, and maxims offer valuable insights into how the law navigates complex situations, ensuring fairness and accountability.